personally want to testify or not? All right. Well, I find that you've decided not to testify with a full and complete understanding of your rights. And so, Mr. Marks, I think you mentioned before that that the defense would not be presenting any evidence at this point.
That's correct, Your Honor. We would just ask for a brief comfort break and we can launch into closing arguments unless the state needs time to prepare.
All right. So at this point, we'll consider the evidence closed so that all that remains now would be any closing arguments on behalf of the parties. And Ms. McCauley, would you be splitting those arguments or what's your plan on that?
No, the state intends just to do a close. The state would request some time to gather our thoughts so we can
Sure.
prepare.
How much time do you need?
I get 45 minutes, half an hour, 45.
Oh, no, that's fine. So we want to come back. It's 11 now. You're saying you want to come back at 11:30?
11:40, yeah, that'd be fine.
Okay.
11:30 is fine.
And that would be to begin with Mr. Marks, and we'll go from there.
It's close to 11. Could we see that maybe like an early lunch? Or how do you want to?
Yeah, I don't know. It's kind of an awkward timing. I'm up to suggestions.
I'm fine.
Or we could just come back at 1 o'clock.
I'm not asking for a lunch break, but if they need close to an hour, like we could just kind of have that this lunch.
It is just kind of weird to start at 12, right? So why don't we just come back at 1 o'clock
Okay, that'd be great.
and we'll go from there. Okay. All right. We'll see everyone at 1 o'clock.
Thank you.
And we're off the record.
I need to figure out how to get somebody. Like the direct memo.
Yeah, that's fine.
That wasn't even like one. I would have gone.
I have to make closing arguments.
Yeah.
It's like
Yeah.
I'll show you. So what you rather by team at 1 o'clock? Right? Yes, more than 2 hours. Just time the leaving in a way where you'll want to. Right?
Yeah, I don't have an 8.
I usually like to keep it pretty simple.
8 eventually build up.
So what I usually.
I follow the.
Gotcha. Okay. But now when 1 o'clock 8, you said it's 20,
22.
no, 23.
And then I think the one you did today, which was 26.
No problem.
Yeah.
Thank you.
Yes.
Oh, you're doing so much better receiving help. Appreciate it.
Thank you. This is very difficult for me. So,
I'm guessing this is in here.
yeah, you don't have to put it in there, though. You can just throw it in the bag. That's just from when I coming. Just throw it in there. Who's Frank?
Hmm?
Who's Frank?
Dad.
Okay.
Dad.
Oh,
That's what I was asking. Did you want them to leave?
no.
I'll take them to leave.
Okay.
Yeah, they were fine. It was just Dan.
You go.
You want to put anything in?
That's okay. Hey, are you okay?
Yeah, you need that.
Yeah.
Okay.
Yep.
He ain't come yet.
Seems like the temperature in this room changed. It's colder in here. So it's not just me. It's like the North Pole. 71. All right.
I just.
This is the closing I wanted for.
Remain seated, come to order.
All right. Ready, Ms. Smith? All right, we are back on the record. And when we last broke, I believe all we had left to do were to discuss, any closing remarks from the parties. It also occurs to me, it's worth at least bringing up and discussing if there are any requests from the defendant for lesser includeds, if those would be applicable to any of these charges, at least to make a record of it, to see if that's something that should be here. So, Mr. Marks, anything along those lines that you want to be heard on?
Yes, I want to state that we're not asking for a lesser included charge, but I want the record to reflect why I'm not requesting that. since the defendant's already charged with what could be construed as a lesser included charge, since they're already in the indictment itself, and that would be counts 5 and 6. If I were to secure a lesser included charge on counts 1 and 2, well, then that would be incorporated by counts 5 and 6. So it just wouldn't make sense to ask for a lesser included charge. So that's why I'm not asking for a lesser included charge.
Well, I don't know if that would necessarily be a determinative thing because 4 and 5 are premised on different factual allegations. If you're asking for a lesser, I think it would be based on the facts as alleged in those particular charges.
Yes. Well, just to be on the safe side, I'll ask for a lesser included on counts 1 through 4.
What would be the lesser on account 1?
Just child molestation. That would be lesser than count 3 and count 4. But I understand the trial court has the discretion to consider a lesser included charge where it's warranted legally and factually. So just in case I'm overlooking something, I'm going to ask for a lesser included charge on the more serious counts, which would be count 1, 2, 3, and 4. And I'll leave it to the court's discretion. Thank you.
All right. And so to that end, Ms. McCauley or Mr. Peoples, would you have any response to this issue of whether the court should be considering in its verdict lesser included to any of these counts?
So Judge, as to count 1, station in itself would be inappropriate, lesser included. I just brought up the statute actually to review it. As the Child Molestation Act does not need to be completed as part of to meet the elements of enticing. So I actually think the correct lesser included would be attempt to criminal attempt to commit enticing a child for indecent purposes based on the evidence that's been presented in this case. I don't think that child molestation is the proper lesser included for that offense.
I'm with you there. I'm not really seeing a mismatch in the elements, but I'm sure there might be some other misdemeanor potentially out there.
Yeah, I'm not exactly sure. I'd have to look at the statute. As to counts 2 and 3, when the evidence is clear that is based on an act of sodomy, and I believe this is included in the state's bench brief, that lesser included offenses would not be appropriate for the offenses of aggravated child molestation. The reason being, one, if there's evidence in the record that there's more than contact, or there is sufficient contact of the child's mouth with the genital area or vice versa, that is sufficient to establish the act of sodomy, which is as the basis of aggravated child molestation, would stand alone. Now, the lesser included of sodomy for the offense of aggravated child molestation does not apply in this instance because that would take into account, that would disregard the child's age, which is an element of aggravated child molestation, which is not present in sodomy, but there is no, basically there's no defining difference between those two statutes absent the child's age.
That's the only additional element is
Correct.
the age, right? And I don't know if remind me if this was made part of the evidence. Did we have Miss Ward's birthday? I'm curious, was this where or how close to 16 she was or where that was?
Testified that she was 15.
Right.
In her testimony, it's also included in the forensic interview, as well as her mom testified to her age as well. So I don't think that the age is being disputed.
Right. Okay, and I did see that on page 4 of your bench brief about lesser included and citing to Frazier, 331 Georgia Appeals 263.
Yes. As to the of child molestation, can't recall if defense counsel asked for a lesser included. I think the only applicable lesser included for count 4, which is the offense of kissing, would be simple assault. Based on my recollection of the case law, I believe that is the only permissible lesser included, other than, and then count 5, the only permissible lesser included would be sexual battery.
All right, well, on that point, it's my understanding that lesser includeds are appropriate if there's slight evidence and on how the evidence comes out. The defense here as presented was that this act never actually occurred. There hasn't really been a kind of a dispute over age in any way. It either did or did not happen. It's kind of an all or nothing thing. And so I don't see the defense as bringing up these issues. And as pointed out by the case and by the state's arguments, I don't see on 2 and 3 and specifically why just child molestation without the aggravating element and count would be at play here. So the issue is preserved, but it appears to me that all 5 counts should be considered on their face based on the evidence that's presented during the trial. So turning to closings then, Mr. Marks,
Yes, Your Honor.
floor is yours.
May it please the court. It's the defense's position, clearly, that the state has failed to provide sufficient evidence to prove beyond a reasonable doubt that the defendant is guilty of any of the charges reflected in the indictment. What I would like to do is provide just a thumbnail sketch summary of the witnesses who testified. And then secondly, dive into the meat of my argument, which is separated into 5 different factors. And our contention is that each of these 5 factors constitutes reasonable doubt, warranting an acquittal in this case. There were 10 witnesses that the state had to the stand to testify. The first one was the complainant, Miss Michaela Ward. This is the alleged victim who, in essence, alleges that the defendant engaged in oral sex with her. She said that she and the defendant had oral sex. She testified that she's 15 years of age and that this took place in the area where she was essentially his student and he was the gymnast instructor. And it is our contention that there's no proof that they actually engaged in oral sex or had any inappropriate physical contact whatsoever that the state would have to prove in order to prevail when it comes to all the counts. Our contention is that the contact between the defendant and the complainant was nothing but appropriate, and any allegation to the contrary is lacking in credibility. The second witness is Logan Dansby. This is the friend of the complainant, and apparently Miss Ward, Michaela Ward, she told Miss Dansby about the alleged incident and about what transpired. So Miss Dansby would be essentially the state's first outcry witness who testified. The third witness is Marcia Ward. This is Michaela's mother, and this is a witness who in essence stated that she had a conversation with her daughter, Michaela, and that Michaela had told her about this alleged incident. And then also Miss Marcia Ward is the one who calls 911, this would be essentially the second witness who testifies as an outcry witness. The fourth witness is Nika Porter. This is the gym owner. This is the person who testified remotely by Zoom. She testified, among other things, that yes, the defendant works there in the capacity as a tumbling instructor. She also was at the gym. She indicated that she had no problems with the defendant and that she had known him for a very long time. She also testified that she noticed that the garage door was open and there was no testimony, as far as I can recall, to the effect that at some point the garage came to a close. And that's the essence of Ms. Porter's testimony. The fifth witness who testified is Officer Sewell, Sewell. He was the first responding officer to the scene, or rather the first responding officer, not to the scene, but to the residence of the alleged victim. And he was an outcry witness too, because he spoke with Miss Michaela Ward, and she told this officer what transpired, and a report was generated after that. This is an officer who did not have the alleged victim taken to an emergency room for a rape kit, despite the fact that that would be appropriate protocol according to the nurse who testified, which was Tricia Sheridan. The next witness who testified for the state, witness number 6, is Detective Jamie Gore. She is the lead detective in the case. She's also an outcry witness. The complainant told Ms. Gore what transpired and et cetera, and Ms. Gore then launched her investigation. She, among other things, indicated that she left a business card at the gym in an attempt to do some further investigation, but nobody responded to that business card, and that's Detective Gore. She also did testify that given the length of time that transpired between the actual incident date and when Ms. Gore spoke with the complainant, that there wouldn't have been enough time for a meaningful rape kit test to be done anyway. That's what Officer Gore said, among other things. And this is just a thumbnail sketch. The 7th witness who testified for the state is Alina Moore, and she indicated that she also was a student or client of the defendant in the context where he was her tumbling instructor. Alina Moore also knows the complainant, Miss Michaela Ward. Alina Moore indicated that she didn't see anything unusual between Michaela Ward and the defendant, but Alina Moore did say that the defendant had engaged in inappropriate discussions with her and had actually made unwelcomed romantic advances towards her. However, she did testify that she was in her 20s. I think she said she was 21 at the time, and also that the defendant was 27. That's the 7th witness. The 8th witness is Dr. Trefinia Wallace. She is the therapist for the complainant, Miss Michaela Ward, and she's another outcry witness, and she testified as to what Michaela Ward told her. She also testified about therapy and cognitive therapy and things like that. And I believe she testified that and a lot of the outcry witnesses admittedly did testify that the demeanor of Miss Michaela Ward is consistent with somebody who actually be abused in this type of way. Her demeanor indicated sadness and things like that, some anxiety, whatnot. So that was the therapist of Miss Michaela Ward, witness number 8, Dr. Trefinia Wallace. The 9th witness who testified was Tricia Sheridan. She's an expert witness for the state. She's a nurse. She's an expert when it comes to rape kits, and she talked about the how that rape kit is done, how it's conducted, how it should be done within a certain time frame, the significance of a rape kit, how in many instances you can administer a rape kit and there'd be no signs of sexual assault or anything like that, which doesn't mean it didn't happen. It just means that in many instances someone could be abused in a sexual way and there still would be no physical evidence showing that abuse had been done. But in some cases there is evidence, and the only way to know for sure is to do that evaluation. But it's not in and of itself dispositive, and that's a summary, I think, of Dr. Sheridan's testimony. And the last witness, witness number 10 for the state, was Monet Patrick. She was the witness who actually did the forensic evaluation. She sat down with the complainant in this case, Miss Michaela Ward, and she's another outcry witness. Ward did communicate to Dr. Patrick what allegedly transpired. And Michaela Ward told Miss Patrick, among other things, that the defendant and Miss Ward engaged in oral sex at the gym. So that's a thumbnail summary of all of the 10 witnesses. Now what I want to do is I want to move to my argument. I'm going to divide it into 5 sections. Number 1, the first point is this. Here we have multiple outcry witnesses. If I'm not mistaken, I think we have 6 people who testify that they spoke with Miss Michaela Ward, and Miss Michaela Ward confided in them that she and the defendant engaged in oral sex, which, if true, admittedly, would constitute a crime given that the complainant is age 15 and the defendant at the time was age 27. But nevertheless, we have a situation where you have multiple outcry witnesses which clearly establish that Miss Michaela Ward made these statements to them, but that in and of itself doesn't establish that that incident actually happened. So our contention is that somebody simply saying that they heard an alleged victim say that this happened over here doesn't prove that it actually happened. So that's point number one. Point number two is is lacking in any physical evidence or video footage evidence or anything like that. Admittedly, just because you don't have physical evidence and just because you don't have video evidence, that doesn't prove that something didn't happen. But still, that's a whole, I would contend, the defense would contend, in the fabric of the state's argument, state's contention. We don't have DNA. We don't have evidence of physical injuries. We don't have the administration of a rape kit, even though it could have been done on the day that Officer Sewell went to the residence, which would have been about 3 days later. That wasn't done. That doesn't mean that if it had been done, it would have been revealing. But still, that's something that could have been done. And in some instances, a rape kit can be done and it can reflect certain things like possibly DNA or physical injuries. So we don't have a rape kit. We don't have physical injuries. We don't have DNA. We don't have any video footage. We don't have any physical evidence at all. Point number three, nobody at the gym was really interviewed other than Alina Moore, the seventh witness, and Nika Porter, the fourth witness. And I'm not sure who spoke with them. I don't know if it was a member of the district attorney's office or somebody else, but they were also present at the gym and they were spoken to by authorities. But nobody else. The officer did, the detective, Detective Jamie Gore, did indicate, she did testify that she attempted to do further investigation by leaving a business card there, but nobody returned the call or anything like that. However, no additional steps were taken by this detective to see whether there are any video cameras inside of the gym location or whether there were any other people who go to that gym who may have observed something or may have not observed something that could be informative. Admittedly, we do have Alina Moore's testimony, and she does clearly establish that the defendant was there, is a tumbling instructor, is Michaela Ward's tumbling instructor. But her testimony doesn't establish that the defendant engaged in these inappropriate physical contacts. So that's point number two, the absence of physical evidence. And then three, the fact that nobody was interviewed other than Nika Porter and Alina Moore. Number four, we would also contend that the evidence that the complainant's demeanor is, or the testimony rather, defendant's demeanor at certain points in time is consistent with somebody who is a victim of sexual abuse. We would contend that that in and of itself, still, it doesn't prove that these acts happen. Somebody's demeanor is not proof that this actually happened. And the last point that we would bring out concerns some of the inconsistencies that we have present in the state's case in chief, namely that the complainant, in addition to stating that she and the defendant engaged in oral sex, also stated that the defendant took his fingers and touched her genital areas with her fingers, that he touched her vagina with her fingers, and that was brought out in direct testimony of Miss Michaela Ward. However, in the forensic interview, she never mentioned that to the forensic interviewer, even though the forensic interviewer at certain points specifically asked her whether the hands were used for anything other than when he had his hands on her head during the oral sex that was being performed. And she indicated, first she said, I don't remember, and then asked again when Miss Patrick was asking the complainant further about whether there was any other body parts involved. The complainant said no, which is inconsistent with me, which was that the defendant used his fingers and touched her genital area. So that's an inconsistency. I would anticipate the state would say, well, just because there's this inconsistency doesn't mean that the gist of what she's saying isn't true. Sometimes people forget things and forget facts, and that doesn't mean that they haven't been victimized in such a horrible way. But it nevertheless is an inconsistency. So we have, again, just a summary of the 5 points. We have multiple outcry witnesses, but that doesn't establish that this happened. We have the absence of physical evidence, the absence of video evidence, the absence of DNA or anything like that. That's point number two. Point number three, our contention is that more people could have been interviewed, or at least there could have been more attempts made by the detective to interview more people, and that just did not happen. Point number four, evidence of someone's demeanor being consistent with someone who's abused. in and of itself doesn't establish that this crime was committed. And then lastly, the fifth point, we have the inconsistency when it comes to what the complainant stated in response to direct questioning on examination concerning how the events took place, where she stated that the defendant, among other things, used his fingers to touch her genital areas, and the forensic interview that doesn't mention that. So these are 5 points, and our contention is that each of these 5 points in and of themselves constitute reasonable doubt that warrants an acquittal. This defendant is an innocent man, and he was simply being a gymnast instructor, a tumbling instructor, and everything he was doing with Miss Michaela Ward was entirely appropriate. The allegations that he approached her and he had contact with her that was inappropriate in sexual nature are blatantly false, and the state can't prove otherwise. The state's required to prove its case beyond a reasonable doubt. The defendant is presumed innocent until and unless the government can prove otherwise with convincing evidence. And our contention is the government can't prove this case beyond a reasonable doubt and has not done so. And as a result, the defendant should be found not guilty as to all counts. Thank you.
Right, Judge? As to the state's case, Your Honor, the state presented 2 days to a day and a half worth of testimony before this court, when the state only had the obligation to present the testimony of one witness, Michaela Ward, and the state has gone beyond its burden of the requirement to prove the case beyond a reasonable doubt, and we would ask you to render a verdict as such. However, before we get to that point, let's talk about the crimes that the defendant is charged with. In count 1 of the indictment, well, before we get to that, let's discuss dates not material. There is a date in the indictment. It's June 7th of 2017. However, the date is actually not a material element of any of the offenses on the indictment. And so should the court find that any of these acts occurred in Fulton County at any time, the court is authorized to find the defendant guilty. And that is set forth in 1732.1 in its subsection B. Enticing child for indecent purpose. The indictment sets forth that on June 7th of 2017, the defendant did entice Michaela Ward to go to a location, 800 Wendell Court, for the purpose of committing an immoral and indecent act with Michaela Ward. The law says that intent to commit the act may be demonstrated by the defendant's acts following the enticement. And the fact that Michaela Ward may have participated or consented to the enticement has no consequence on whether the act of enticing a child took place. The elements require solicit, entice, or takes any child to a place whatsoever for the purpose of child molestation or an indecent act. The movement element is satisfied when the taking involves enticement or persuasion. So when the defendant is engaging with Michaela Ward via Snapchat, when he's sending her these very explicit messages, when he is eliciting her to send a nude photo of herself and returning that nude photo, those acts of persuasion and enticement to go to the gym, to set up this private session in order to commit these sexual acts is the basis of the enticing charge. The physical taking is not required, and it is satisfied when the defendant invites a victim to a location, even if mutually agreed upon, for the purpose of sexual contact. What are the facts and evidence? We know that Michaela Ward was 15 years old. We know that she went to 800 Wendell Court, which is a location in Fulton County, to engage in sex acts. The communications were done via Snapchat, and they hatched this plan together. It was for Michaela to sign up for a private session, and that when she went for the private session, they would commit these sex acts that they had discussed. Hopefully this is playing. Maybe not. Okay, great. It's not playing. Okay. For whatever reason, it's not playing, but that portion of the forensic interview is when Michaela Ward is discussing that they had come up with a plan, and that they had planned to do this. That is the element of enticing that is set forth in the indictment. As to count 2, which sets forth the defendant is charged moral and indecent act for the purpose of putting the accused mouth on the female sex organ of Michaela Ward with the intent to arouse and satisfy the accused sexual desires, said act involving an active sodomy. What are the facts and evidence for this offense? Michaela was 15 years old. She described it as going down on her. The defendant placed his tongue on her vagina in her genital area, and that Michaela was uncomfortable and stated she kept trying to close her legs and he kept going with it. In fact, Michaela provides some incredibly graphic details, both in her in-court testimony as well as in her forensic interview, about how this felt, where her body was, where the defendant's body was, how they were positioned, and how this act made her feel, both what she anticipated and what actually happened. Wait, hold on, Your Honor. If I could just have one moment. Oh. Yeah, I saved PowerPoint. It's okay. It's all right. I'll keep moving. Count 3 is when the defendant placed his penis in the mouth of Michaela Ward for the purpose of committing an act of sodomy with the intent to arouse and satisfy the accused's sexual desires. In this instance, the facts and evidence are Michaela was 15 years old. The defendant put his penis in her mouth. He held her down, pushed it down with force, guiding her, telling her what to do. And Michaela referenced both in her forensic interview as well as on the stand that he was pushing it back in her mouth, or where at one point she gagged, a breaking point where she couldn't go back any further. And then on count 4, the child molestation for the kissing of Michaela Ward by the defendant as an act with the intent to arouse and satisfy the accused's desires. So, for kissing, a simple kiss may constitute an immoral and indecent act if it is done with requisite intent. Whether the intent exists is considered after all of the circumstances surrounding the acts of which the accused is charged, including words, conduct, demeanor, and motive. In Michaela's forensic interview, as well as during her trial testimony, she talked about how the kissing was the first act that set off a number of other acts that are included in the indictment, but the 2 counts of aggravated sodomy, as well as count 5, the offense of child molestation, and that it was as they were kissing, they moved over to the couch, and then he pushed her down on the couch and performed oral sex on her. Given the motive and the manner in which the kissing happened, it clearly demonstrates that the intent of kissing Michaela Ward was to arouse the sexual desires of the child for purposes of this act. Kissing also precedes all of the other sexual acts. He kissed her after everyone left the gym using his mouth. Lastly, count 5, which was the touching of the child's genital area. I think there's a little bit of confusion in defense counsel's recitation of the facts, in which he indicates that it was digital penetration. It's actually the touching of the child's vagina, which is what is charged in the indictment, which was clearly demonstrated in the evidence, both in the testimony of Michaela Ward, during her in-court testimony, as well as in her forensic interview. But simply, she stated she was 15 years old. He touched her genital area during the incident. And in fact, she remarked on it in her forensic interview as saying that when she was getting dressed, he came over and said, like, you have to get more comfortable with that. Touched her genital area, and it had caused her to have a reaction to it. And he remarked upon it. In Michaela Ward's forensic interview, she says, he came over and said this to me. And he said, you need to get more comfortable with it. And I was like, whatever. And I just put my spandex back on. It's the exact section of the forensic interview that she discussed it. However, Michaela Ward testified in court that the defendant touched her vagina as well when he was performing oral sex on her. So the court can find that there is sufficient evidence in the record for either one of those instances of touching the child's vagina to satisfy count 5. Frankly, the state probably should have included a count 6 on the indictment for an additional touching of the child's vagina during this incident. Now let's do a brief overview of the incident. We know that this incident date, although it's not material to the indictment, happened on Wednesday, June 7th. We know that because Michaela Ward testified, as well as Marcia Ward testified, that Morgan Ward's birthday was on June 8th. And that following Morgan's birthday, there was a birthday dinner at Benihana's, and that was on the Friday. And then we know that Michaela makes her disclosure to Dr. Wallace on June 10th because we have a therapy note with that date on it that corroborates Michaela's disclosure. That is also the same date as the Fulton County Police Department report. Michaela Ward also states in her forensic interview that she was going to tumbling and that she believed that it happened on a Wednesday. She didn't know the date exactly, but she was going, and she usually went with her sister's friend. We know this incident took place 800 Wendell Court. It was a gym that was owned by Nikki Porter. The defendant was a volunteer at the gym. That Elena Moore had sought out lessons from the defendant at this gym because she was cheering at Georgia State University, and that Elena Moore was best friends with Morgan Ward, and Morgan Ward's little sister's Michaela Ward, and had asked Elena to take her to the gym as she was going to be on the varsity cheerleading team at North Atlanta High School and wanted a new skill. This is the outside of the gym, including the back of the gym, where you see these 2 doors that were frequently referenced as being the roll-up doors. And then the front part, which had the reception area that Marcia Ward discussed, Michaela Ward discussed, Elena Moore discussed, as well as Ms. Porter. Then we have the inside of the gym, which has this waiting area, again referenced by multiple witnesses, and then the interior of the gym, which is exactly how Michaela Ward described it in her testimony prior to seeing the photographs, as well as in her forensic interview with this trampoline in the back and then this couch present where these incidents took place. The state presented the testimony of 10 witnesses, the first being Michaela Ward. Michaela Ward testified that she was, the state's going to provide a little bit more of an in-depth interview or overview of the evidence, but Michaela Ward testified that she was 15 years old at the time. She was attending North Atlanta High School, and that she was best friends with someone by the name of Logan Dance. She stated that in 2017, she had completed a year of all-star cheerleading at the Marietta Stingrays, and that she'd been a level 2 cheerleader, and that she'd done JV cheerleading, but that she had made the varsity sideline cheer team. And that she wanted to get a new skill, specifically a back tuck, and sought out additional training. And she learns about this gym through her sister's friend, Elena, that Elena was going to because Elena was trying to make the cheerleading team at Georgia State University. And she ends up asking Elena if she can go with her to these tumbling classes that are held at 800 Wendell Court. And she ends up meeting the defendant, who she referred to as Coach DJ and identified in court. Elena drove her to and from tumbling classes along with another friend, Margaret. Michaela said that there would be inappropriate conversations in front of her, talking about dating and relationships, that the defendant would sometimes make comments on her body during the tumbling classes. And Michaela referenced this type of conversations and communications were inappropriate, especially in light of her experience in other gyms. Michaela stated that she was in a group Snapchat with the defendant. In her forensic interview, she talks about messaging the defendant on Snapchat, but that initially she was in a group chat with with Elena, and Margaret, so they could talk about scheduling, and going to the tumbling classes. Ultimately, Michaela says that she messages the defendant privately, and they engage in a private Snapchat where they exchange a number of explicit messages and nude photos. And it is during this private Snapchat that they set up the plan to go to a Wendell court for the purpose of engaging in the sex acts that they talked about. Michaela provided very descriptive testimony in court as well as in her forensic interview, where she described what acts they discussed, what she was willing to do, what she didn't want to do. And even to the point where she said that it excited her, it made her feel special, it made her feel wanted, and it made her want to engage in these sex acts with the defendant. And the fact that he was older also contributed to her wanting to do it. Michaela testified that ultimately they decided to meet up at the gym for a private session. That's what she had told her mom. Her mom had agreed to drive her there, and drops her off. And her mom actually comes in to the waiting area when she drops Michaela off. Michaela says that she practices and warms up a while other people leave the gym. She didn't say there was a lot of people, but there were some other people that were there. She says that once everyone leaves, the defendant begins kissing her. They move over to the couch. He removes her shorts and begins performing oral sex on her. Michaela says after the defendant performs oral sex on her, she then performs oral sex on him and that he ejaculates in her mouth. She said it was dark in the gym and that she could not see across the gym from her, but it was dark enough that she could see in front of her. So she recalled in her forensic interview as well as some of her trial testimony. She said that after the defendant ejaculated in her mouth, he gave her a napkin to spit it out in, and that he put on his clothes and she put on her clothes. Michaela said they walked then out to the reception area where she waited for her mom to come pick her up, and that the defendant walked her out to the car before accepting the money from Marcia Ward for the tumbling lesson. Michaela Ward says that she started to feel bad in the days that followed about what had happened. Not angry at the defendant, not vengeful, not for any other purpose other than she felt guilty and she felt like she had to tell her mom. Michaela also told Logan Dansby. And what was interesting about Logan Dansby's testimony is as this relationship is developing between the defendant and Michaela, Logan is receiving a contemporaneous disclosure from Michaela. So Logan recalled when Michaela first told her about the coach, that she was telling her about the tumbling classes, that she was telling her about the Snapchat messages. And then Logan says that she tells her that they then did the acts that they had talked about and when it had happened. And it's very close in time. During this conversation, Logan says that she told Michaela that this was wrong and this shouldn't have happened. And she said, Logan recalled that she saw a look come over Michaela's face and her disposition change. And Logan says that she needed to tell someone what happened. The person who Michaela Ward elects to tell us her mom, Marcia Ward. Marcia corroborated a lot of what Michaela testified to. Specifically the day in question when she drives Michaela for the private session and walks her in, that she wasn't initially concerned because she had seen other people in the gym there for gymnastics, tumbling, working out. And that when she encountered the defendant, she asked him, could I pay you with a check? And he insisted instead that she pay in cash. So she left to go get cash. She testified that she actually went to the Kroger on Cascade and it took her about an hour to go to and from the gym in order to get cash. When she arrived back to pick up Michaela, that's when Ms. Ward described feeling uncomfortable because she realized that they were the only ones there and the power was out. And she thought it was strange that the defendant walked her out to the car and put her in the car. And she wasn't able to come into the gym. Marcia describes that when Michaela tells her It was days later, it was around Morgan's birthday, and that Marcia had actually captured a photo of Michaela at the birthday, looking very, very sad and very, very solemn, which was unusual for her as her 15-year-old child. Marcia is the one who then decides to report this to law enforcement. It wasn't Michaela's choice, but it was Marcia's choice that she was going to report this to law enforcement. And she goes to the Fulton County PD precinct and then calls 911 from the precinct, and Officer Sewell comes out to their home. Officer Sewell's goes out to the ward residence, speaks to Michaela, and she provides the same information about what had happened as she had provided to Logan, to her mom, to the trial court, as well as in her forensic interview. The case is then assigned to Jamie Gore, who's assigned on June 13th. Investigator Gore testified at the time she was not overly familiar with handling sexual abuse or sexual assault cases, but that she did schedule a forensic interview, that she went out to the location several times. She wasn't able to make contact with anyone, that she attempted to get the Snapchat records, but was unsuccessful in doing so, but ultimately finds Michaela's disclosure credible in the forensic interview in order to obtain warrants. And she also assembles a lineup and has Michaela identify someone out of the lineup. Investigator Gore also talked about why she didn't refer Michaela for a forensic nurse examination or a sexual assault examination, just to perfect the record and make sure that we're using terminology that is appropriate and not antiquated. That is the correct term. It's not rape kit. It is a sexual assault nurse examination and a forensic nurse examination. The court also heard from Nikki Porter. She is the owner of the gym at 800 Wendell Court. I'm using the term owner loosely. This was not a structured environment. It certainly didn't seem like an environment where there was a lot of supervision for these kids. She said that she had volunteers there working for her, but the defendant had filled out an I-9, and that she had actually known him for a long time and held him in a position of trust, would often leave him alone in the gym with the option to close out the gym at the end of the day, and with a key that he would drop off. She recalled the day of this incident and recalled the power had been out, that she left the gym before the defendant did. She also testified that she didn't know who Michaela Ward was and did not train her. She also testified that she wasn't there that often at the gym. I think she testified actually that she worked overnights at Northside. Now, Elena Moore also testified. Morgan Ward's, Michaela's older sister's best friend. She's the one who took Michaela to the tumbling classes, drove the defendant home, chatted with the defendant in the same group chat with Michaela, and that she recalled both inappropriate comments that the defendant made to her, as well as an instance in which they were engaging in tumbling practice and he became aroused and had tried to come on to her, and that she had declined those sexual advances. This is important because, one, it shows that the defendant used his position at this gym as an opportunity to engage in these sexual acts with people that he was tasked with training. Two, it shows the motive to get access. And that this way this gym was set up, this loosey-goosey way of him having people come and sign up just directly with him and get classes with him in a place where he could control the environment, is not just consistent with what happened with Michaela, but also consistent with someone else. Dr. Wallace testified, who provided therapy to Michaela Ward. It was CBT. Michaela provided a disclosure on June 10th of 2017 to Dr. Wallace, and that she didn't disclose it just one time, but multiple times over the course of treatment, and that Michaela struggled with feelings of shame, it happened, and whether or not she had a responsibility in therapy long after the incident took place, well into 2019, and frankly, before this court, in 2024, she's still trying to take responsibility for what happened when she has no responsibility at all because she was a 15-year-old child. Dr. Wallace also testified that Michaela's demeanor was consistent with a child who had experienced an instance of sexual abuse. This that physical evidence is rare. Evidence collection window is 6 to 8 hours for oral swabs and 72 to 120 hours for genital swabs. Even if Michaela had been referred for a forensic medical examination, it likely would not have Monet Patrick, who's an expert in forensic interviewing and disclosures of sexual abuse. She detailed overview of forensic interviews and how children disclose. She stated that most children do not disclose sexual abuse. She was also the forensic interviewer who conducted the Michaela Ward's interview in June of 2017. She stated that Michaela provided contextual sensory details of the incident, that her disclosure was consistent with her cognitive abilities, her developmental abilities, and there was no evidence of coaching, no evidence of suggestibility, and that her disclosure, not her demeanor, but her disclosure was one consistent with a child who experienced sexual abuse and experienced sexual abuse firsthand. Now let's talk about the defense case, or what the state likes to call Predator 101. In order to escape of accountability for his crimes, the defendant does everything in his power to promote forgetting. So what does this involve? This involves a level of secrecy with the child. It involves isolation with the child. It involves gaining the child's trust in order to get access to the child. It involves inflicting perhaps a sense of responsibility and shame upon that child by saying, oh, I've done this with other 15-year-olds, or I'm going to send you a photo and you send a photo back, or engaging in explicit conversations with that child prior to the sexual acts taking place in order to test whether or not this child is going to go through with this, whether or not they're going to tell anyone. If secrecy fails, the defendant attacks the credibility of his victim. This is a he said, she said. It's just her word against mine. You know, she must be mad about something petty. I don't really know what her problem is. When that fails, because the child has no motive, has no reason to make this disclosure, other than the fact that this happened, the defendant then goes to trying to make sure that no one listens by saying, well, there's no physical evidence. You know, her demeanor means nothing. You shouldn't pay attention to that. You shouldn't pay attention to the fact that multiple other people from the gym not only were testified as to the defendant and how this gym was ran, but also corroborating the victim's testimony. As to the fact that there are multiple outcry witnesses actually does corroborate the credibility of Michaela Ward, and the state has no obligation to corroborate her statements in a child abuse case. The testimony of a single witness, if believed, is sufficient to establish a fact, and the child's testimony alone is direct evidence of acts of sexual abuse occurring. There's a lack of physical evidence. There was testimony that also is unchallenged that it's not determinative of whether or not these acts took place. 2 other people at the gym were interviewed, or at least presented at the trial in this particular case. As to Michaela's demeanor, Monet Patrick stated that the demeanor of the child when they're disclosing is not a factor in assessing the disclosure itself, but what she was looking for were the contextual and sensory details of that child's disclosure. So how the child presented is not a factor, but the consistency, the details in her disclosure are. And then lastly, Michaela does not talk about digital penetration. She actually testified to this on the stand as well as in her forensic interview. Let's talk about corroboration. The testimony of a single witness, if believed, is sufficient to establish a fact. Now, would the state have preferred if this incident would have happened with an audience of 15 people who could all come in here and tell this court about what they observed? Absolutely. But the state didn't pick Michaela Ward as a victim. The state did not elect for this incident to happen at 800 Wendell Court in an empty gym during when the power was out, when it was just a 15-year-old and her 27-year-old cheerleading coach. The only person who made the decision to have Michaela Ward at the gym at that time for the purpose of this incident occurring was the defendant. That's why you see the words cast director at the bottom. The state doesn't get to pick its victim. The defendant is the person who picks the state's victim. You should have picked, couldn't have picked a more credible victim in this case. It's playing in here? Yeah, just. Oh, okay, hold on. Oh, you know what? It's not connected to the Bluetooth. That's what it is. Hold on, hold on, hold on. Good catch. Thank you for that. Let's see. Excellent. Let's see if this will work. You heard it though. We're gonna figure it out. We're gonna get this to work. It's still not playing. It's okay. All right. What do you think? No, I gotta kick it up. A child's evidence or a child victim's testimony is direct evidence of the crime, which you would have heard on that. Audio recording would have been the defendant stating that this is just a he said, she said, and not that there's no evidence here. But a child's testimony is direct evidence of the crime itself. And in the second clip, what the court would have heard would have been that doesn't want the state to hit him with something that is unbeatable. All right, so what the court has heard is that the testimony of the victim standing alone is sufficient to support conviction. However, the victim's consistency in outcry statements, statements to police, statements in a forensic interview, and trial testimony can be considered by the finder of fact. So what do we have? With Michaela Ward, we have that she attended tumbling classes with her sister's friend Elena in summer 2017. That is consistent with what Michaela testified to, what Marcia testified to, what Elena testified to, what she said in her forensic interview. It's also consistent with the defendant's jail call in which she identifies her and referred to her as the nerd girl. Second, the defendant had adult conversations with her on Snapchat. That was a disclosure that Michaela made to Logan contemporaneous to when the communications were happening. Michaela tells her mom during the disclosure about the Snapchat messages. Elena confirms the existence of the group chat messages as to scheduling in the gym, and also confirms that that was Michaela was in that group chat. Detective Gore attempted to obtain the Snapchat messages, but was unsuccessful due to how Snapchat operated. In her forensic interview, Michaela repeats the adult nature of the conversations. And then the defendant says in his jail call that Michaela's number wasn't in his phone. So there was absolutely no way that he communicated her, except for the fact that 2 other people that were in that chat remembered it. All of these instances in which Michaela disclosed, and those disclosures were repeated by those outcry witnesses, as well as their corroborating testimony, is evidence of the defendant's, of these acts being committed in this specific case. Next, Michaela testified the defendant performed oral sex on her, and that Michaela had placed the defendant's penis in her mouth. Marcia talked about that when she went to pick up Michaela and the defendant walked out to the car, that she thought it was strange and it was odd. She noted that Michaela was very quiet in the car on the car ride home. Michaela makes an immediate disclosure to Logan. She tells Logan exactly what happened with the defendant. Michaela tells her mom what happened with the defendant. She discloses in therapy what happened with the defendant, and then she repeats that disclosure to the responding officer. And then she also included in her forensic interview those same statements that she made in this courtroom, along with the statement that she felt bad about lying to her mom. It wasn't about the acts taking place. She felt bad, well, it was about the acts taking place. She felt bad about the acts, but she wanted to tell her mom. She felt guilty and wanted to tell her mom. She didn't want to get anyone in trouble. She had no intention of that. She did not enjoy talking about it in this courtroom, but that she had no motivation other than just wanting to come clean to her mom. All of those details, all of that evidence corroborates what Michaela is saying. And it shows her veracity, it shows her consistency. And as the state only has to prove the testimony of a single witness, if that witness is believed, it is sufficient to establish the enticing a child for indecent purposes, 2 counts of aggravated child molestation, and 2 counts of child molestation. And Your Honor, after considering all of the evidence and the arguments by both sides in this case, the state would request that the court find the defendant guilty on the count 1 for enticing a child for indecent purposes, count 2 aggravated child molestation, count 3 aggravated child molestation, count 4 child molestation, and count 5 child molestation. And that's it. Thank you.
Thank you, Ms. McCauley. All right. Just first want to start out by noting that when it comes to rendering a verdict in a bench trial, that isn't something that I have the opportunity to be involved with frequently. And it is one that I view as a weighty responsibility and one that I don't take lightly. And it's one that I'm mindful of the trust that both parties have placed in me to get it right. And it's one that I've tried to devote all of my attention to getting it right. I do want to offer a few observations before publishing a verdict. And the remarks here are not comprehensive. I don't intend them to cover every piece of evidence or argument that could support a verdict. But I do believe that in this posture, I owe it to the parties to explain how I've come to the decision. And the bottom line is that, as highlighted by counsel, everything in this case, as these types of cases often do, come down to the credibility of the alleged victim. And to that end, the law provides pretty clear instructions that I'm supposed to consider all the facts and circumstances. And it lays out all the things that you can walk through and consider. And applying those to this case, after considering Ms. Ward's manner of testifying and her testimony, I found her on the stand to be someone who was calm, she was collected, she was thorough and intelligent in answering questions and during cross-examination. The story that she provided was not one that was inherently improbable. After over 7 years that this case has been pending, it's also not one that is varied. It is not one that has changed. It has remained consistent. And as outlined through several of the witnesses that testified that have been labeled as outcry witnesses, again, those provided corroboration. It showed that she reported this soon after it occurred. And then again, after 7 years, we haven't been provided a reason of why she would make up a story like this, why she would stick to it, and even today, be here today, swearing to tell the truth. And as was outlined in Mr. Johnson's jail call, without any indication of why she would be making something like this up. Additional physical corroboration is always nice to have and welcome, but it's not legally required, and it doesn't raise a reasonable doubt in my mind as to her account. And the law instructs that punishment is not to be considered in reaching a decision in the guilt and innocence phase. So the bottom line is that I find, based on the evidence presented, that it is my duty to find Mr. Johnson guilty of all these counts. And I will have completed a verdict form indicating as much, and I will have that entered into the record as Court's Exhibit 1.
Can we approach?
You may.
Thank you. Your Honor, as to the form of the verdict, we don't have any objection to the form.
State also has no objection to the form of the verdict.
Again, this is something I'm not sure if it's even a procedural or legal necessity when it's a bench trial, but I did think it was worth completing and filling out in this format to make the record clear. Ms. McCauley, is there any reason why we should not proceed with sentencing in this case?
No, Your Honor.
Mr. Marks?
No, Your Honor, I think my client would request a reset to come back for her sentencing and to not be remanded into custody during that time frame. But I recognize that is within the trial court's sole discretion.
Well, Mr. Marks, on that point, because I don't know what the ultimate sentence will be, there may be something still worth discussing there with the state. But because I anticipate that it will involve some form of confinement and probably a lengthy form of confinement, if we do delay sentencing, my intention would be to remand Mr. Johnson into custody and off bond simply because of the conviction in this case. I think that the incentive to evade jurisdiction of this court would be too high.
Your Honor, in light of that,
And Mr. Marks, if you want to confer with your client before, we move into sentencing, I'm certainly open to that as well. If there are other individuals he needs to have here, if there are things you think he wants to go over with you, again, these may be things that aren't so much a conversation with me as they may be with the state.
may I have 10 minutes?
Yeah.
Thank
Let me
you.
know when you need me.
Thank you.
I'd be on the call. Yeah, I think. That's the question. Double copy. You can do it here, you can do it. So. You got your contact number, you got. I did. I'm probably, you know your mom and no. Okay.
Much better. I don't know if this is work, I don't know if this is working, cause they've been acting up. Oh,
No, it was.
It was
today.
I can see.
Yeah.
I think I'm less. I wanted to send you back, but
I don't know where your glasses would have been.
it's on my desk.
Oh.
Yeah.
Oh, also I can get back there.
They always on my, I would have given you my keys. My keys are like always right here. I'm like, I'll take it. It's X, Y, and Z. And I was like, yeah, it's just so weird. So it's okay. Got a lot of guys on piano. You don't get anything until like 2 class. All the time. Much harder. Morgan's big lawn. Yeah.
I just, it's not. But I. It's a hustle. Yes, it is.
That's how you get okay. She had a Howard. My friend's house.
Did she tell you she's
Yeah.
now? Did she tell you she was? Did she say she was?
Yeah. Getting my dog for her.
I get it.
Yeah.
But it doesn't.
No,
go
she's
away.
so-
I can't lie. At least for. Yeah, it's okay. It's okay. Yeah.
Yeah.
Yeah. I think, yeah, the worse the cases, the better.
That's true. That is true because hearing that voice, I agree.
Yeah.
No, I was feeling last night, oh, I was like, we gotta fix this. The second time this has happened. I was like, I don't understand. Why are you doing why? Oh, I know, that's not.
This is that's order.
In courtroom advocate, but if you don't know that, you're done. Oh, deal. We did, we did. And you have to create, so. It was very. Yeah,
Something like that.
It wasn't bad. Yeah. Like, don't know, it's not down bad. And then she said something.
Yeah. You never feel better, but sometimes you get the lunch.
And that I understand. This is.
That's the worst effects of it.
Yeah, I could see.
That's
Why I understand.
and the younger they
It's not the first time.
Yeah. So.
Like a lot of his things, just where.
No.
So he just says that's what I don't, you know,
Yeah, yeah, they just see back there, so. I'm asking. It's good today. Final. Yeah.
yeah.
She's starting.
Yes. Okay, no, that is one of the things.
Yeah.
Yeah.
I think they should, because when there's reciprocity across all their states,
Right.
it would make sense.
Yeah, I'm so surprised there's three door.
Yeah.
Like I can't predict this one.
The Georgia bar. I said, so you could say.
Ours is for 7 years, and then you can take that without penalty.
Oh, really?
I just for less than that, you can take me times.
Oh, I can do that.
It's not hard. It's not hard.
Yeah.
You have to take, you just do the essay portion,
Okay.
and then the professional responsibility, didn't have professional responsibility.
I took that already. It's same period.
I expect them.
On the Georgia part, yes, but not for this one. So that's.
She's so much younger.
We didn't have to do multiple, no, we didn't have to do multiple, because it's just essay.
Which is what I prefer.
Yeah, I did that on the essay portion. And as long as you have your MBE, it has to be over, I think it's like, what your MBE has to be like at 180 or something.
So Texas on the higher end, but it's 270.
As long as you're 270, you're fine for that.
Okay.
You don't
yeah.
have to retake that.
Yeah, no, I'm above that.
Yes.
I think the highest requirement for any state is like 270. Right.
So you're fine.
Okay, that's
You can just take the train. It's really, it's
But I
not
can
bad.
take that at any point.
Yeah,
You
yeah.
can
You
say-
take it July or July or February. You take it, it's the first day of our
But there's no like career requirement that I have to wait for like
7 years to wait in without the exam. But the two, you have to.
Thank you.
two.
Yeah.
Okay.
We will get you the
Yeah, because I was like.
flash drives. We'll get them for you.
Okay.
Take the Georgia bar, because I said you need to use your Texas, so I can transfer this for rural state.
Do you have, yeah, what did you, it's just the, it's just the essays. It's
Yeah.
just-
No, all ours were
What
on,
are they based on? Whatever the legislatures are. So changes the law of the legislature, because usually what's reflected on the exam.
Nice, okay, perfect.
The reason I was asking is because normally, so
Well, we did too.
they have a C and a number on it.
Yeah.
With 8.
So,
So I wanted to scan those.
Oh.
because I had the multiple choice, that's the
I
tuition.
scanned whatever was in.
what it was already on, but we didn't put it on T's, it's just on our computer.
Okay.
So like,
My friend's sticky.
we haven't put it, normally I would
Okay.
put it on a disk, cause it's just easier for me to keep track of it.
Yeah.
It's just all in
Now
there.
when you apply for a process,
Oh,
you do it, but that brought up
I see, okay, yeah,
the part,
book art,
Dallas.
okay.
And
Oh, nice.
Thank you.
That's fine. Yeah.
we're just, I'm here well, I'm scared. My over is coming.
Little conventions. Yeah. Yeah, we're kind of working together. Yeah.
I have really nice big birds, walls,
Yeah.
great parks, like I bought them, big two little ones, they were, and you see will be free in November, and had some for. But they have like all those pools and the water parks and stuff that
Yeah.
comes with the breakfast. So, I bought them like the year pass.
Yeah, she.
Been a minute.
It's not. Yeah.
Yeah, they try to keep me subdued.
And August,
I think it was one of these cases.
you're not.
I think it was years.
So there's something good.
Needed.
Oh, I might
think that's it. I'm gonna keep
that up to the- I got called out
on they got.
emergency.
Oh.
So I got phone and keys.
Okay, I got you.
I just.
The short version.
Okay. Sure. Oh. Yeah, it's great. No, I'm not ready. I am ready, yeah. I'm gonna ask for a reset for 7.
Okay. I'm gonna ask to do it today, but I'll let him. make
I get it, I understand.
Okay. They have it.
Yeah.
So, so you talked to someone.
I got it.
Yeah. Yeah, honestly.
So. So I'm always very careful. Yeah. Yeah, she's got your back.
Public opinion.
Trust me, I remember from night court.
Yeah.
I would read everything they write in the comments.
I'm not as strong as you think.
Here we go.
That's what I stood.
Colonel, let me get my clients' relatives. They don't know you.
Do you have a stapler?
All right, we're getting started. We are, yeah. We are.
Wow.
We are back on the record. Mr. Marks, do you have a updated position on whether we should proceed with sentencing?
Yes, Judge, after speaking with my client, my relatives, we're gonna be asking for like a 4-week reset for sentencing purposes. So that his relatives and my client can work on having some additional people come and provide statements in support of the client. My client, I told my client that we have 2 options: to handle this all today or to handle this sometime down the road. So that's at least our position. The state may have a different position.
All right, let me, Ms. McCauley, if you have an initial reaction to that.
Yes, Your Honor. I understand defense counsel's request. I would request to go forward with sentencing today. Michaela is here. She is home from school this summer. She does go back in the fall. And then her sister is also here from Texas. And she does have to return to Texas. So I would prefer, while she has the support of her, and also both of her parents are here, I would prefer that we go forward with sentencing today. If the court is inclined to grant defense counsel's request, the state would just request that we do sentence or Michaela has to return to school, which is at the end of August.
Well, let me follow up. Would there be a more specific date other than the end of August?
August 10th? Okay, August 10th.
And I'd also point out that I don't see a reason why we couldn't begin a sentencing hearing and also then resume it at a later date if we need to. And so that because the individuals who are here now have traveled, they would be able to present any testimony that they want to. But Mr. Marks, you were about to add something.
Yes, Your Honor, I was about to add that point. We wouldn't have an objection to having the state's witnesses provide testimony today in the context of sentencing considerations. And the defendant can get his friends and family here at some later date to present testimony when it comes to sentencing considerations. And then the state's family and friends, witnesses can view this all by Zoom or virtually or whatever, and maybe even add additional things on Zoom if they want to. So I don't have an issue with bifurcating the sentencing. I recognize the dynamics. My client has asked for additional time, and I believe his family is too. Is that right? Yeah. So they've all decided they want more time to get more people in, which is fine, but that's our position.
Well, I want to address another component of this as well. One is that it's not necessarily, a numbers game, just who has more people testify. The other thing I'd point out is that generally in our case management order is that I say that sentencing either is going to occur soon after the conclusion of trial or within about 3 days. So that's generally the expectation. However, with a case as serious as this, I would be completely open to allowing both sides to marshal as much evidence as they want. However, kind of the looming issue here is whether it matters at all, because this is a mandatory minimum case. And so if there is, I think the question that needs to be answered, and I don't know whether that can be answered definitively at this point or not, maybe it can, which is, as I understand it, under 17-10-6.1, even after a jury trial, the state could still have the discretion to deviate from the mandatory minimum if they so chose, and if both parties consented to a deviation. And that may be something that the state is considering in this case. I don't know. I look at the kind of the difference between the pretrial offer and the mandatory minimum, and that's a wide gulf. And but however, the state's going to know their case better than me. They're going to have spent more time with Miss Ward and her family, and they get to ultimately make the call of whether they think the mandatory minimum is appropriate in this case. I think that there could be plenty of mitigating arguments to make on why 25 years to the door may not be. Even if Mr. G not accepting responsibility, is that a true reflection of his culpability and of the harm that he caused in this case? Again, it's not my call. But if the state needs more time to consider that, I'm willing to let them have that time, of course. So, Ms. McCauley, at this point, is that something that you've made a definitive decision on?
Yes, Judge, and just for the purposes of having this conversation, I think it might be helpful to put that reasoning on the record. The state, in considering its pretrial offer, did evaluate the facts and circumstances of the state's case, including in that evaluation and the pretrial offer was one sparing Michaela Ward from having to testify. As the court is aware from review of perhaps in camera inspection of other records, that this was something that was very difficult for her to get through.
Well, let me just make this clear. I'd never got a copy of those records, so I do not know what's in them.
Okay, well, there's indication that this was an incredibly difficult event for her to move past, and it disrupted her life in a number of ways. And so the state's pretrial offer contemplated primarily sparing her from having to testify. Secondary to that, it considered the defendant's position and the relation and the dynamic that was established with the tumbling classes, him being an instructor of students, and the responsibility that was bestowed upon him as part of that responsibility. So in making the pretrial offer, that was contemplated. After trial, the state will not be deviating from the mandatory minimum based on the fact that Ms. Ward had to testify. That was an incredibly emotional challenge for her. It was a journey to get to this point, and that this has unearthed a lot of trauma that did not need to be revisited had the defendant taken responsibility, which the state understands he had no obligation to do. And consistent with recommendations that have been made in other cases, the state is not going to be deviating from the mandatory minimum. That being said, the state is also not going to request a maximum sentence for any of the offenses on the indictment, and will ask for sentences to be granted concurrent.
All right. Mr. Marks, in light of the state's position, that essentially it sounds like it's going to be a joint recommendation of the parties as to the appropriate sentence, which is driven in large part by the statutory mandatory minimums. It doesn't look like there's really any discretion to be deployed here. And so I wonder what purpose is served from a continuance or a reset.
I don't know what the state's asking for, that's the thing.
All right, well, why don't we start there, Ms. McCauley?
Sure. As to count one of the indictment, the state would be requesting a sentence of 30 years to serve 25, with the balance to be probated. As to count two, the state would be asking for a sentence of 25 years to serve, life on probation. Count three, state would be asking for 25 years to serve, life on probation. Count four, the state would be requesting 20 to serve 15, balance on probation, which has count 4, 5, and I believe count 1 have to have a year of probation as required by 1710 6.2 section C. And then count 5, the state would be requesting 20 to serve 15 with the balance to be probated. All counts to run concurrent for a total sentence of 25 years to serve, life on probation.
Well, Your Honor, in light of that recommendation, which is actually the minimum from a global standpoint required by law, if I can just have a brief opportunity to explain to my client that you don't have the legal authority to give him anything less than that anyway. We might be able to resolve this today with sentencing, but I still want to be able to consult with him because he's very impacted emotionally by this sentence, the verdict rather, and he may want to put this off anyway for whatever reason.
I understand. You can,
May I have a brief moment?
of course.
Thanks.
Or you can take the radio. Go to the third. But if you got it first, it's your gift, right?
Your Honor, my client wants to handle sentencing today. In light of the developments.
All right. Ms. McCollum, does the state have any evidence to present in aggravation?
Not an aggravation, but Ms. Ward would like to make a victim impact statement. Or Michaela. Would you like her to come to the podium or go to the witness stand?
I think wherever she's more comfortable. I think the podium would be fine though.
Should I? It's like a year ago, or should I just keep reading? You just read it. Okay. Each time I try to sit down and write this, I'm stuck with my fingers on the keyboard and my eyes glued to my laptop screen, glossing over as my vision becomes just as cloudy as my thoughts because where do I start? How do I start? How do I unpack 7 years of blame, guilt, shame, sadness, and many other emotions I can't find the words for, from the heavy-duty box sealed with industrial tape tucked away in the deepest part of my mind? At 15 years old, I thought I knew exactly what I wanted. I thought an older man finding attraction to me meant I was special, different, desirable. I didn't think about the consequences. I didn't think about the powerless feeling I'd have with his hands on my body, the instant regret I would have the moment the lights turned off in the gym, the blame that I would place on myself and still hang on until this day. I didn't think about how this one moment would change the trajectory of my life. Although the 15-year-old in me still holds on to the guilt I have, at 22 years old, I know that there is absolutely nothing I have in common with someone 12 years younger than me. That to convince someone 12 years younger than me that I'm doing them a favor by giving in to their sexual impulses would make me a sick, twisted, and manipulative individual. And then to have the audacity to want to go through a trial knowing the events that occurred. I know that regardless of how I feel about myself, someone whose prefrontal cortex was more developed than mine and knew the implications of the situation well enough to try to flip it back on me and try to convince me that I wanted this more than him is someone who should never be around children or any woman at all. I refuse to believe that as a grown man at 27 years old, you did not know right from wrong. And as a 15-year-old in completely new territory, you sensed my curiosity and innocence. Now that piece of me is gone. And as much as I try to gather all the broken pieces, I can never quite put it back together the same way it was placed in my spirit at birth. But today I have peace. Today I have joy. And today I have hope. This chapter is closed and I can finally go through the process of healing without having to look over my shoulder or doubting whether I'm at fault or not.
Thank you, Ms. Ward. Anything further, Ms. McCollum?
I think better than the state.
Ms. McCollum, just to complete the record, can you detail any prior criminal history on behalf of Mr. Johnson?
Yes, Your Honor. As to the defendant's criminal history, the only offense that I'm showing is a driving without a suspended license. It was from 2014, which preceded this incident. I don't have any other arrests, or convictions.
And that one resulted in a conviction?
So it's GCIC restricted, so I cannot see the outcome of the case itself.
All right, so that may just be an arrest and not something appropriately considered.
It's only an arrest, yeah, from what I can tell.
All right, Mr. Marks.
Yes, Your Honor. May it please the court. My client lives in the area, in the Metro Atlanta area. He works at a seafood restaurant. As far as I know, there have been no indications that he's had any brushes with the law, other than what the state is saying. So we're going to ask that Your Honor give the defendant a sentence that the state is recommending, which I believe from a global standpoint is the minimum required by law anyway. And also, my client's mother and aunt are here as a show of support for him. Would you please stand? This is his mother and his aunt is here, but she's out.
I've seen her through the trial, and so I recognize that she's here as well. Thank you for being here. I want to make sure that we're clear about what the potential ranges are for the aggravated child molestation. I read that it's a term of imprisonment not less than 25 years and not exceeding life imprisonment, followed by probation for life. And is it the state's understanding that that is also one that requires the 1 year of probation?
No, Your Honor.
And
Because the statute contemplates probation in its sentencing provisions. However, 16.6 for aggravated child molestation is actually included as in the list of serious violent felonies subject to the sentencing requirements of 1710 6.1. The other 3 counts on the indictment, the enticing a child for indecent purposes and the 2 counts of child molestation, are subject to the sentencing requirements of 1710 6.2, and which is for the sexual offenses. I don't know why the legislature elected to not include the sexual offenses that are set forth in 6.1 and not include them in 6.2, but it is, the statute reads how it reads. 6.2 subsection C requires that there needs to be at least 1 year of probation accompanying a conviction on or sentencing on count 1, count 4, and 5, unless the sentences are being run consecutively, in which only the last and final count would need a split sentence.
all right. So what I wanted to confirm here is that for 2 and 3, when Mr. Marks says he thinks that you're recommending the minimum, that might not be entirely accurate, because wouldn't the minimum just be a straight 25 years to serve?
No, it has to be accompanied by life on probation.
I concur with the state. I believe that's an accurate.
Yes,
Uh,
there is
Followed by probation for life. All right, I see
by
that.
probation for life.
Okay. Mr. Johnson, you're not required to say anything in sentencing whatsoever. But if you'd like to, this is an opportunity for you. All right.
Okay. Tell the judge what's on your heart. Can you do this from a seated position, Your Honor?
That's absolutely fine.
Talking to this. I'm going to try to do this or speak the best I can. Through this whole demeanor, this whole trial, this whole case, I don't, as a coach, I tried to do my best to not disrespect anybody, not to hurt anybody. And if I did in any type of form or fashion, I wish somebody would have told me. I would have definitely corrected what I was doing if it was out of content. Over the years of this case, I've stayed out of trouble. I obliged by each rule and regulation that was given to me. A lot of my credibilities, I don't feel like they're being taken in consideration of how long I've been coach, how long I've stayed out of trouble, how my record is nowhere near of the substantial of this case. Uh, the lack of evidence from everything, from saying that we talked on Snapchat and there's no evidence whatsoever in that aspect, and that's one of the biggest things that has been pointed out. Uh, I'm really hurt from the simple fact that like off of just vocal is enough to put me away for half my life, and I would never understand it. I don't feel like I am going to get it or understand it. I just I don't know, y'all. I've literally did everything that was been asking me about this case since day one. This is the first time I've been able to speak. Uh, I don't want to say too much because I don't want to say the wrong words, if that makes sense, because I don't want to say something, but it's taken the wrong way. To the family and everything, I have no animosity to the family. I have no heartache or anything like that whatsoever. I honestly just wish the best for the family and their endurance in life and stuff like that. I honestly just wish that we both could just went on about this and just kept living our lives. Honestly, through this whole there, I'm no longer the so-called person that they portrayed that I am or was at that time. Yes, I was a younger man at that time, but during the time of of course of 7 years, I can no longer look at my life or be the same person that I was at once, for the simple fact what is being pushed upon me, what has my life been going through, the changes that I have been going through, the way I had to adapt, the new lifestyle I had to come across. I am no longer that 27-year-old boy. You know, I better myself. I've become an uncle. I have become more humble with myself at being a male and a well-being on this earth and stuff and everything else. Like, I'm sorry for this whole ordeal that what so-called transpired or for us to even get to this point that we're sitting in court right now. And I honestly wish it was a better way that this could be resolved besides me going to jail for 25 years and losing half of my life and not being able to really, I'm not going to say enjoy or I want more so say I'm gonna miss on a lot of things. I'm not gonna be able to witness my niece becoming a young woman. I'm not going to be able to start a family. I'm not going to be able to hold on to the friends and family that I once had and stuff and the life that I built now as the man that I am now, not who I was years back or how everybody is looking and judging me off something years ago. Uh, I find it unfair for the simple fact, like literally, I know it's not my job. I'm not a judge. I'm not a lawyer. I'm not a defendant. I'm not neither or of these people. But it would never sit with me. It would be hard to sit with me. There's just simple fact I have to be confined almost to the highest degree level with no evidence to put me away into confinement. Oh, I wish it was something like leaser or something, which I feel like I shouldn't have to take, but 25 years of my life going when there's nothing to prove for me to be going that long is really hard for me to take right now. I literally, it was from the time that this has happened, nobody has spoken to me. Nobody has really tried to get a justification of what happened. I literally just been put in handcuffs and taken away from my life and my family. And then I have to go to jail and be sit and looked at and criminalized as a criminal off of nothing that nobody can prove off of justification. This is the first time I've ever spoken in the last 7 years. So I'm sorry that my words are stumbling or I don't have the right mindset or heart set or words to really give, but this is the best I can give right now, hearing what I heard. It's mind blowing. I don't understand honestly how I'm able to speak right now because this is a lot, sir. I've never done anything of the success of the statute. And like I said to the family and everybody else, if you feel like or have been disrespected in any case or any form of fashion, I truly do apologize. I really do. But once again, to hold somebody in contempt, the feeling like of somebody who in his past, like off of something that could have been probably resolved, or in a sense, stuff doesn't seem the way that it seems in that case. Like I say, all I can say is that I'm hurt. I apologize to the family again if I did hurt you, if I did do anything to mess up the lives of this family and everything else. But like I said, just like I just wish that it would just more be seen that I did not commit something for me to be gone for 25 years off of just words alone when the hard evidence is not there. And I have done everything the court and everybody has asked me to do within the course of 7 years. And my whole entire background and everything else that I have been doing prior to being a coach, prior to working, prior to my little criminal cases of driving with a suspended license and stuff, learning how to drive and stuff like this. Like these are things I feel like are being not looked at, and it's just once I'm not gonna say it's being one-sided, but I don't feel like I'm being justified of the fact that there is nothing to put me in confinement, like away, because of everything that I personally have heard. It's just words. So in my heart, I feel like in that case, during the job that I had at the time, any child could have said something about me and I would still be in this predicament because I am a male in a coaching position where it allows me to be around kids and I have to touch them to teach them how to flip.
All right. Well, Mr. Johnson, there are a few things that I think I could see your perspective on, which is there's no reason this case should have taken 7 years to get to today. That's an injustice to you, it's an injustice to Miss Ward and the members of her family. And I think that this case strings along. Maybe it lulled you into a sense of complacency. And then all of a sudden things hurtle to a conclusion here that I could tell from the verdict that this is catching you completely by surprise. But it's certainly, I would tell you, not because of a lack of evidence. And I think that while the things you bring up about the lack of a history and the circumstances of the case, every case should be judged on its own merits. And maybe that's something that isn't going to happen here. I would very much have to disagree with you. And I think that you'll certainly have the time to think and contemplate on that as well. As recommended by the parties, the sentence on count 1, enticement, would be 30 years to serve 25 years with the balance on probation. Count 2 would be life on probation to serve 25 years. Count one will be concurrent to count two. Count three would be the same sentence, 25 years to serve, life on probation. Count four, that's going to be three would be concurrent to count two. Count four, 20 years to serve, 15 years with the balance on probation, four to run concurrent to count two. And count five would be 20 years to serve, 15 years with the balance on probation, concurrent to count two. Special conditions would be those required by statute, which would include to complete and comply with all conditions of the registry. Are there any other special conditions that would be need to be reflected on the final disposition, Ms. McCauley?
No contact with Michaela Ward or any member of her immediate family.
All right. Anything else?
Nothing from the state.
Be no contact with Ms. Ward or any member of her family for the term of this sentence that is on felony probation. For any technical violations, this will fall into the sentencing option system with a sanctions cap of PDC or RSAT. Mr. Johnson, you have the right to seek post-judgment relief from your conviction of these crimes, either by making a motion for a new trial in this court or filing an appeal to a higher appellate court. If you want to file a motion for a new trial or an appeal, you need to file that motion or notice of appeal with the Clerk of Superior Court of this county within 30 days. Generally, that's something Mr. Marks is going to take care of on your behalf. And that's something you're going to want to discuss more with him before those 30 days elapse. If a motion for new trial is made and the court denies it, then you would have 30 days from the filing of that denial in which to file with the clerk of court your notice of appeal. You have the right to have an attorney represent you on the motion for a new trial and the first level of direct appellate review. And if you cannot afford to hire an attorney, the court will provide you an attorney and a transcript of your trial at no cost. These all being felony convictions, you have a period of 4 years from the date that your sentence in this court becomes final to file a habeas corpus petition. Is there anything further that we need to have on the record, Ms. McCauley? Mr. Marks?
No, Your Honor, thank you.
All right. I'm told that someone from probation has joined us on Zoom, and they may need to inform Mr. Johnson of something. Is this Mr. Kuzu?
Yes. Hi, Your Honor.
Good afternoon.
Good afternoon. Mr. Johnson, once released from Fulton County Jail or wherever you may be housed, you would have to report to the Atlanta DCS field office. That would be located at 276 Memorial Drive, Southwest Atlanta, Georgia. I will send also those instructions to your attorney. I'm sorry, I came in on the tail end of the plea. Is this a sex offender plea?
It is.
Okay, so I will send over the sex offender conditions to both parties, and they can check off which terms they would like Mr. Johnson to abide by while on probation.
Well, that's kind of complicated given the situation. Is there a way we can have my client brought back to court next week so we can go through all that paperwork? Because it's fairly voluminous. And if he's sent to prison, there's no way that's going to be accomplished.
That's fine by me if the court will allow that.
Ms. McCauley?
It's fine, Judge. The court will, or the state will accommodate the request by defense counsel, and I'm happy to confer with Mr. Marks in advance of what conditions may be inapplicable.
All right. We will, I mean, that won't prevent, I think, the final disposition from being entered on the record. But
No, it should not. It's just a matter of logistics because there's a lot. I've gone through those forms before, and it takes a long time to go through everything. And if that's my job, then I'm going to need time to go through that and have him brought back at some point later and have him sign off on that stuff.
Well, alternatively, Mr. Marks, I think you generally make regular visits to the Fulton County Jail. You could visit him there and confer with him there. Is that?
Well, actually, I lost my county ID yesterday, so I can't get into the jail until I find it. So I'm not saying I won't find it, but it's something that needs to be done logistically, and I want it to be done before he goes to the prison because it's a lot of paperwork. Usually the probation officer goes through that with the defendant after case is resolved. I know they're not here, but I do think we probably have a plea and arraignment court date sometime next week maybe, and maybe we can just do it then.
I don't think we have one officially scheduled next week, but we can still bring him over and plan to bring him on Monday for an unscheduled conference.
That'd be great. Thank you. And if the probation
That's
department
fine.
can get me the forms, I don't know if the probation
Sure.
officer or two to help with that process, but that'd be great.
Sure, I'll send them over to both parties.
Thank you.
All right. If there's nothing else for the record, then we'll be adjourned on this matter. Thank you all.
So I asked, can I at least get some time to get my home in order?
That's not gonna happen. Yeah, we really trust that. Your Honor, may we be excused?
You got some numbers?
Yes,
Thank you.
Because you got, you need that back, right? Yeah.
Hello.
Sit.
Like you.
Don't worry about it.
Okay.
We need a team.
He wants to know if she can log in. It's up to them. They got policies. Yeah.
We'll be baby angels.
I can't believe you never had to do a.
I've never had to do a gun shop before.
Yeah.
You want my number?
You know what he never said though?
612 5213. Well, why don't you give me your cell? I'll give you a call now, because I got a cell phone too. What's your number? That's my work number, my landline. This is a different number. Oh, what's your phone number? 404 484. Richard Marks. I'm calling you now.
You guys don't forget about me.
I won't. I'll be back tomorrow with their,
All right.
with your flash drives.
Okay.
Promise.
Thank you.
Can I talk to you in the back real quick?
Sure, absolutely. Yeah, yeah.
Thanks.
Lauren, I'll take the stuff.
Okay,
I'll be here.
just say, I just want to say bye to my kid. She goes.
It'll be less than a minute, I promise.
Okay.
Yeah.
Set up a minute. Wait on it.
Okay.
Oh, wait on it. You did it on. Martha, always a pleasure.
Where are you going?
Yeah, just anytime to learn from my superiors.
Oh, same. Oh, Terrence, you made it. You missed.
What do you say?
I don't know what they're talking about right now, but what. Final motion, you try. We already got,
Yeah.
I don't know what the timeline is. I'm not 100% on the process. I'm not going to lie to you there. But he'll be appointed